So, Joe, it's 11 o'clock. Do you think we should make a start and then add people?
Sure, absolutely. I've had a
Thank you.
message in any event. As I'm sure the participants will know, there are a number of us speaking this morning, including Calma, Paul, and also John McNamara. John is currently undertaking his new practitioner's course this morning, and it's overrunning, so it should have finished by now. I think it's just an hour-long session, actually, from 9 till 10:30. So he's going to join us a few minutes late, and Calma, I imagine, is in the same situation. So let's make a start, I guess. So I'll begin by introducing myself very briefly. I'm currently the careers director at ICCA, having taken effectively a year out on maternity leave, having had a lockdown baby, always an experience in these COVID times. And I normally practice at Garden Court Chambers, which is a very large multidisciplinary set based in London. My practice is typically publicly funded work. It ranges from criminal practice to public law and inquests and inquiries. So that's a broad introduction to who I am and what I do. I'm going to ask each of the panelists as they arrive to introduce themselves and just say a little bit about what they do. And we're really lucky this morning. We have fantastic practitioners spanning the whole course, actually, of publicly funded work. So given that we've got Paul at the present time, I'll pass over to Paul, and perhaps you could say a few words about yourself, Paul.
Thank you, Joe. Yes, I am a children law practitioner. I practice exclusively in children law, with about 90% of my work being care proceedings, so public law children work. That work is all entirely publicly funded. I practice from Senate House Chambers in Northampton, but I live in London, so pre-lockdown involved a lot of travelling. Because the majority of my work was based on the Midlands circuit. And I've been there now 4 years.
Excellent.
It takes a while to remember at this stage.
And I've been in practice, I think, for about 15, which actually makes me feel exceptionally old. I'm not going to lie. When you suddenly realise exactly when you were called and how long you've been at the bar.
If I mention that I was called in the last century, that'll probably make you feel better.
So you will have a really broad depth and range of experience actually from this panel, because you've obviously got Paul, still relatively new, Paul, although an old hand already, frankly. Then you've got me, and then you've got John, who's in between my level of call and Paul's, and then you've got me, and then you've got Calma, who's obviously a silk. So you've got hopefully you'll have a real breadth of experience in that regard. I practice primarily on the Southeastern Circuit, and I would certainly encourage all of you to take a look at the circuit seminar that's taking place later in the day, because frankly, not everything is concentrated in London. And as you'll already appreciate, there are amazing sets on circuit, and actually sometimes a very different type of work, actually. So I would highly recommend it to you, and have a look at that. So let's have a look, I suppose, if we move on to have a little chat about what is your typical day, Paul?
Is
there such a thing?
There is no such thing as a typical day, particularly at the moment, as I'm sure we're all certainly who are practicing used to at the moment. Everything has changed in the last 6 months. Before March this year, typical day was always spent in court. There is no such thing, certainly at my level of call, and certainly in my work, as a day out of court. Your prep is done in the evenings or at the weekends, and that's the reality. Because it's a court, this role and these roles are court-based. So typical day for me was travelling to somewhere in the Midlands, wherever it happened to be. I practiced from as far across as Stafford all the way up to Nottingham and down and then in London as well. So travelling in the morning, I'd meet my clients at court. I'd meet my opponents, try and work out what we were going to be doing that day, and then go from there. And that could be a short 1 hour, 2 hour appointment, or it could be a full day or part of a multi-day trial. More recently, that commute has become far easier. It tends to be from my living room to the desk, but it doesn't change. there is still a meeting with a client, whether it's by video or phone, and the same with your opponents. And then you carry on with whatever it is you're doing that day. If it's a long trial, which are less frequent at the moment, or alternatively, if you're doing something short, you will wait your allocated time before the judge and hope that they're not running too late. And it's very easy to get very annoyed that they're making you wait for a couple of hours. But the reality is, whilst I might have one, maybe two cases, they've got 6 or 7 to deal with, which they're getting through.
Excellent. Okay, so we've just heard a little bit about from Paul. I see John, you've just joined. Fantastic. Welcome. And John, I should probably just very briefly introduce. He's the I think you're still the assistant secretary at the moment, aren't you, at the Criminal Bar Association, soon to be secretary as that time passes. John, we've introduced ourselves. I've explained that you were delayed this morning because you were undertaking your new practitioners program, The Joy, and we've introduced ourselves very briefly. So perhaps you could tell us a little bit about yourself, the work you do.
Hi everyone, I'm John McNamara. I'm a criminal barrister. I also, for my sins, do some proceeds of crime work. My practice is about 70% crime, and within that I defend maybe 65% and prosecute 35%. And all of that work is publicly funded, either legal aid, CPS, or other prosecution agencies, and spend all my time in criminal courts, really, in one form or another.
I think you're also the Assistant Secretary of the Criminal Bar, as I've already said, and part of that role involves representing junior members' interests at the Criminal Bar. Would that be fair to say? That would be fair to say. Jo would know more than most. She's been integral for the CBA for so many years. There's a recent has been set up for young barristers, including pupils and very junior tenants, and the issues that they face. And we are doing our best to try and improve the entry to the profession, to ensure that in those early years people stick with crime. There are a number of projects we've got underway which we hope will assist us in improving things for you guys coming through, and hopefully for you considering, if you're on the verge of considering whether crime's for you, it might just push you over the edge and decide that you want to give it a go. And it's a fantastic job. I think we can all agree. I think Paul would agree, John would agree. I think the family and criminal bar is probably one of they're probably the friendliest bars, actually, frankly. And I strongly commend the specialist bar associations to you all. They are a rich source of resources, of help. They run seminars, they run outreach programs. So have a look at those too in the future. John, we were just dealing with what a typical day really looks like. And I think me and Paul concluded that actually there is no such thing as a typical day generally. But what would you say your typical day is? I appreciate in COVID times, slightly unusual, but perhaps pre-COVID and hopefully post-COVID. Yeah, I mean, pre-COVID, I think the criminal bar is more of a lifestyle than necessarily a sort of a typical day sort of thing. And the lifestyle varies so wildly. You can go from an early finish on a Wednesday at 11 a.m. in the morning. You've got the entire day free and no work to do. So you can act at your leisure, to a last minute return on a Tuesday evening, which means you have to cancel your plans if you've got any. And you spend all night working a case because you've got, a 5-day case or longer that you need to prepare for, and do that all overnight. So it's certainly a lifestyle, and those are probably, for some people, is a downside. But in terms of job satisfaction, having worked as a paralegal before I came to the bar for a number of years, I would struggle to find another job which was as satisfying, or which had such moments which really stick with you, and
probably shape you as a person as you find at the criminal bar, if that helps. What do you really ask the question?
No, absolutely. And just for the students who perhaps aren't familiar with the language that we use, a returned case is typically a case where a barrister is instructed on a case. It may be quite a case of some significance, say a 3-4 week trial even sometimes. But unfortunately, owing to various difficulties in listing or a trial that they're currently in overrunning, that case then gets returned to another member of Chambers, and that's what John was talking about. So picking up one of those cases the night before the trial is due to start, for example. So it's a very topsy-turvy practice, and that certainly happens in family as well, albeit I think it's fair to say to a slightly lesser extent, Paul, than perhaps in crime, owing to the different listing practices of the courts.
Yeah.
So. My typical day, again, it varies. I have a broad spectrum of in terms of my practice area. I can either be in court conducting a trial, in an inquiry, alternatively an inquest, or in the High Court dealing with a judicial review matter. Very much like Paul's and John's experiences. Lots of things happen at the last minute. And frankly, there's never a typical day. I don't think I've ever had a day that's the same as another day in my practice. And I'm sure that's equally true for Paul and John. Every day brings with it fresh challenges, but it's one of the things that actually I find keeps me interested. It's stimulating, and it makes it a very rewarding job ultimately. If I can move then to obviously the publicly funded bar, we hear this homogenous sort of expression or terminology. Hi Karma, how are you this morning?
I had a horrible time. It didn't recognise my password. I had to redo it all, re-log in. I'm so sorry, everyone.
Don't worry at all. I think we're all encountering this brave new post-COVID. Well, I say post. We're not post, are we? COVID world where we're all using different platforms and tech. I'm certainly not the most tech savvy, so you have my every sympathy.
I thought I was okay, but there we are. I'm here.
No, not at all. So, Karma, just to give you a recap, and also just to give you an opportunity to introduce yourself very briefly. We've introduced ourselves. We've explained what sort of practice we have, and Karma, you have a fantastic practice. So, perhaps you could tell us a little bit about yourself.
I'm a criminal practitioner mainly, based in Leeds, now deputy head of Park Square Barristers. I also do family work called 97 Silk 2016. And I've really quite, not that unusually from my area, but I would say unusually for the bar, I really did, particularly when I was junior, just work out of one court centre. It was really my home court, and when I had young kids and stuff, that was so important for our family life. So that was very significant for me.
And Karma's very modest, of course, because you've just come off of the back, haven't you, Karma, of being awarded Inspirational Women in the Law Barrister of the Year this year, which is fantastic. So congratulations.
Thank you so much. Yeah, that was a really lovely evening, actually. It was really nice to have some good news in lockdown. So that was great.
Oh.
About my cases, because I think at the sort of that level, you're dealing with the sort of murder and abuse, and it's all horribly miserable, and nobody wants to hear about that on Saturday morning.
But no, probably not, I'll be frank. but in reality, those are the cases that we deal with, and it's one of the things that makes it such an interesting job, actually. It's probably, I mean, you're practicing at the very highest levels, of course, and in the more junior years, obviously, individuals are less likely to be doing that type of work, but nonetheless, you're building that level of experience up, and hopefully also acting as a junior to people like Karma, as a second barrister in a case, on those sorts of cases.
That's right, and just to pick up on that, it's, you know, for the sort of work that I'm doing, there's jobs of being the main junior who has to be a certain level of qualification, obviously, to be able to, you know, deal with the case if I'm off sick or something. But then in a lot of cases, there are roles for very junior people in publicly funded work as either disclosure juniors, or there are sometimes other roles, particularly within the CPS. And I won't say the hourly rate the hourly rate is fantastic, because it isn't. It might only be at times sort of £30–40 an hour. But, you know, I always do try and look at who needs to be at home, you know, for those sort of cases. And I think particularly if you're on maternity leave and things, you know, or you had to have a sabbatical, or, you know, you're a male but need to be at home, that sort of having a regular coming in of paperwork that just keeps you ticking over. You know, there is office-based works even within publicly funded work.
Absolutely. And I think perhaps it's just worth mentioning at this stage that, of course, publicly funded work in terms of our presentation today is very much focused more on the criminal family side of things. But in reality, publicly funded work encompasses so many more areas, such as housing, community care, immigration, asylum, as I said already, the inquiries, inquest side of things too. So it's really quite a broad church, actually. And I think certainly from a student perspective coming into this, you will find that some chambers are very highly specialised. So they are a criminal set of chambers or something of that nature. And John, your chambers is much more perhaps like that, isn't it?
Yeah. In terms of what spread, Joe? Sorry. In
terms of crime and extradition and those types of things. And then I know certainly, Kalma, your chambers covers a much broader depth of work. For your primarily family, but with ancillary matters. And Garden Court is again a publicly funded set that really covers every area of public funding. So that you will. So one piece of advice that I would give is really have a look at the type of work that you want to do, because actually the publicly funded bar is such a broad set of practice areas and disciplines. It's not limited, as I say, to either family or crime. It's perhaps just worth flagging that up in this session.
Also, Joe, I would say that I remember as a student sort of writing off areas that I didn't really understand, because I just thought, you know what, I just want to be a criminal barrister because it's the coolest one. You get to wear the wig, and it's the fun one. It's the fun one I want to do. But as I've spent, Paul's laughing at me. As I've spent more time, I'm sort of 3 years in now as a tenant. You begin to be introduced to different areas that complement your main practice area, but they pay in different ways. And so, from a business point of view, it's quite a neat way of supplementing income, maintaining your skill set, and also just building a different presence and a bit more resilience in the marketplace at the minute, which is quite difficult. I'm seeing a number of questions about funding, which I'm sure we're going to come to.
We will certainly come to funding in a moment. And just picking up on what John said in relation to that broad practice area, and really don't close down any avenues until you've got some experience of the different types of law, because you may have your heart set on one area, but actually find that when it comes to doing pupillage or undertaking work experience, you really enjoy another area. And as John said, that's really important, firstly, to look at that sort of resilience aspect and commerciality aspect, but also one area of law often informs another area of law. So even if you're dealing with a purely criminal case, you're often also looking at potentially community care aspects. For example, children on remand, where should they go? The local authorities' duties towards those children. What are the police duties towards those children in relation potentially to trafficking? Those types of issues. So there are all sorts of overlapping issues. In terms of family law, it may well be that there are concurrent care proceedings. If you've got a handle on both those things, then you're in a fantastic position, because you know what to ask for from the family proceedings to use in the criminal proceedings, or if you're in the family proceedings, you know what you want from the police, for example. So there really is a real strength, I think, to that. Perhaps we should come to funding now then, in that case, given that there are lots of questions. I've not been following them all, but certainly...
So I've been following some of the questions down the side for you. So there is really the obvious question to ask anybody who's working in publicly funded work at the moment, which is that you hear so many stories in the news about particularly criminal barristers struggling financially, being overworked, and about the underfunding of the whole of legal aid across the board. So what comments would the panellists have on that issue, and whether it should affect your decision, I suppose, to come publicly funded work at the bar?
I don't know if Karma, do you want to start with that one?
I'm quite happy to be quite frank about fees, because I am really quite open about it, because I think it's really important that the bar explains to the public how underfunded the criminal justice system is and the other justice system. So I absolutely get that that is fundamentally right. And if you're working in an area where there is a plethora of barristers, then you absolutely need the volume of work through publicly funded work to be able to make a very good living out of it, I would say. I'm talking about crime, really, which is still much lower paid generally, I would say, than family on legal aid. I know some family practitioners don't agree with me, but I think like for like on my working day, I still think that is the case. So it's right that we send out a public message about low pay fees and about how important it is for us to be paid more. The flip side of that coin is that, you know, it is often of young students understanding you almost cannot live as a criminal barrister, that you literally cannot pay the rent if you're a criminal barrister. And my experience has been that simply isn't the case, you know. So you can still earn well above, you know, the sort of teacher profession, much, you know, well over double that if you were at the criminal bar, and even not being unbelievably successful, I would say. I don't know if people think this is the wrong message to give out. But I just think, yeah, I think that if you are, all you have is sort of a bail application, which is £100 a day, that's not take-home pay. There's, you know, that's turnover. Lots have got to come out of that. Yeah, that's a really bad day, and you're going to struggle to pay your rent, particularly if you're in London. I'm not going to say otherwise. But in our place, in sort of, I would say outside of London, we're going to try and make sure that somebody, even if they've got just one hearing like that, has got, sorry, if they've got a hearing like that, they're going to have 5 of them. And all of a sudden, if you're doing five bail applications, you've earned £500 a day, and that is more than enough to survive on. You know, I would say, what is the average daily rate in something like a rape or a robbery? 350 to 450 a day for a junior barrister?
400 baseline. 400 baseline.
Yep. Yeah.
Thank you. So I think, yeah, I think that's the message. And I think, you know, obviously in Silk, we earn well over double that rate of pay per day, in addition to advisory work and things you can do. So, I mean, if your aim from the bar is to make as much money out of it as possible, then I imagine you're not in this session at all, because this isn't for you. But you can still make a very comfortable living out of it, out of the publicly funded bar. Just I hope there's no journalists in the session.
Well, Karma, on that note, I'm happy to tell people I'm 3 years in after pupillage, and for the last 2 years, my gross earnings have been over £100,000.
Yeah.
I, as I told you all earlier, I mainly do crime. There is some other supplementary work within there, but it's all related to crime or the proceeds of crime, and some civil bits that relate to that. But it's important for people to understand that, yes, the funding issue at the criminal bar is a ongoing issue that is, Joe, probably more than anyone in this room, has been fighting for a number of years. But thanks to Joe, in large part, the juniors, the way the fee scheme has now been restructured in the Crown Court, we'll have to ignore the Magistrates Court, it's a slightly separate issue. But in the Crown Court means that a lot of the money that was in the pot has been reassigned to those who are engaged in the kind of work that you're going to be doing in the first 2, 3, 4 years of your practice. And so what it means is, I hope that the average earnings of criminal barristers at the start of their professional lives should, under this scheme that we've currently got, increase. There is still a lot of work for us to do, and that is work that is being done. And there is a review pending. It might be a couple of years until we get the results of it, to increase the funding for criminal barristers. But while you read all the horror stories, and don't get me wrong, there are some people at the criminal bar at the moment who are struggling really badly financially. I'm absolutely not trying to put this through rose-tinted glasses. I'm only giving you my own experience of my practice. That's all I can inform you about. You will need to make up your own minds and go away and do your own research. But for me, I'm earning an amount that I'm really comfortable with, doing a job I really love. And there's a reason I'm still here doing it. I could earn more money going and do something else, but I'm very happy where I am and what I'm earning.
And I think, Paul, do you want to just chime in on the family side of it?
Yeah, my experience is largely the same as John's. I'm 4 years in at this stage, and in terms of level of earnings, it's broadly similar. I won't go any further than that. But the reality is, I think the real difference between certainly at the junior end of criminal, family, or publicly funded practice is unless you are in court, you're not earning. Now, I don't know if that's John's experience, but certainly in family, our fees are made up only of our advocacy fees. There isn't, as in civil, for example, in civil work, for example, there is more available in terms of written work and advisory work. I don't earn on a daily basis unless I am in court or doing something related to court. So, for example, having a conference with a client. So at the very early stages of practice, that means that it's a fairly relentless diary of court commitments to make sure that you are both building your experience, but also bringing enough work through the door. As you get more and more experienced, more and more senior, and I think that this is what Karma was alluding to earlier, that there is more advisory type work available, and the nature of the fees as they do increase means that you can take time away to do periods of preparation. But certainly at my level, I'm in court 5 days a week, every week without exception, and prep fits in around those days, whether they're long days, short days, or somewhere in between. And I know that I've seen there's a question in the chat bar about preparation and commitment, or commitments rather. And when John was talking about picking up returns at 6 o'clock on a Tuesday night, it will be familiar to all of us. That's the thing that comes. Probably all 5 of us here will have cancelled plans, cancelled potentially holidays, cancelled time off to pick up work that you need to do. And that's the level of commitment that, whilst your colleagues in other areas of law may be able to sit in chambers and draft their advices, or sit at home at the moment and draft their advices and do that more paper-based practice, the commitments and the time the court time that these areas demand mean that there are a lot of sacrifices to make along the way. But the converse of that is that I certainly, and I think the other 3-4 of us here, I would.
No, I think that both all of the panelists actually have given you a really helpful insight into the funding issues that are currently facing the bar. John's completely right. The position was a little different, I think it's fair to say, about 3-4 years ago and before that, because the most junior were actually being paid appallingly, and we did a huge amount of work to really put money back into that level. So to give you a broad idea, I think the least that a junior will now earn for a week-long trial is just over £2,000. It's something like £2,300, I think, is the lowest.
Yeah.
So that will give you a concept of where the money is. A little bit like Paul says, the money ultimately in funding is all in work, in court work. So the funding scheme for crime in particular is very much within trial work. So the smaller hearings that Karma was alluding to earlier, which are the bail applications or mentions, plea hearings, pay very poorly, actually. They're the £100 or so things. And obviously nobody could survive on one of those a day effectively moving forward. But of course, everything is relative. And you also have to take into account the average income in this country, which is still £26,000 a year. So actually, I think it's fair to say that notwithstanding the very significant constraints that we all face at the publicly funded bar, we're also very lucky. It's just that with that work comes huge responsibility. And that's really what Paul was also alluding to in terms of the sacrifices that individuals would need to make. And I've seen within the questions that have been asked is about flexibility. Does it make regular commitments more difficult? Well, the short answer is it inevitably does make them more difficult from my perspective. It doesn't mean make them impossible, but it does mean that you have to be very, very controlled in terms of your time and have very good time management skills. And it may be that unfortunately, as Paul said, plans do go out to the window, because if you accept a brief that you're going to be in trial for the following day, you ultimately have the responsibility, because you are standing up in the morning making those submissions. And I think certainly across the criminal bar and the family bar, great strides have been made in trying to really develop well-being. and really develop and have more of a balance in our working lives, because actually it can be relentless, and we all do understand that, and it's obviously very difficult. It's certainly more so, I would suspect, in your early years. Don't know whether anybody else wants to chime in on that point.
I think in terms of commitments and juggling, it gets easier, because at the beginning, you know, when you first start in the second six, that first trial that you have in the magistrate's court is, you know, it takes you hours to prep it, and it's half a day. It's a really short trial, but you agonize over every question and every issue and everything. And as you become more experienced, you narrow down the issues, it becomes easier to streamline those. Of course, the severity and complexity of the cases goes up, so you're always sort of catching up to some extent. But your working process becomes easier, and you learn, as Joe says, to juggle things a bit better, and you learn to make time for yourself. Also, ensure there's enough time to make sure you're properly prepared. Sorry, Carm, I think you might want to come in. I jumped over you.
No, not at all, John. No, you didn't. I typed something that I handed over to Paul to answer. But I absolutely agree with what you say. I've always sort of seen it as a plateau, sort of climb and plateau phase. So, you know, when you start, everything takes you forever. I mean, most people don't have huge family commitments then, so it's kind of okay. It's those people that do that I really, really feel for. Because I was able, as a, you know, second six and stuff, just to work really, really late, and I'm really sad, and I quite enjoyed that actually. And I stayed at Chambers then and worked there, so that when I went home, I never went home with my books or my papers. I felt I was done, and for me that was really important. That meant, because so much work is outside court. But and Paul, what you were saying is absolutely spot on. You in that cycle where the money's not amazing, but it's fine. But it's only fine if you go to court every day, which means all your prep is in the evening or at the weekend. So you're in this sort of cycle. And again, I don't hugely mind that, because I haven't got a whole lot of hobbies or anything that I would probably do over the weekend. But and then so you're chasing your tail whilst you're trying to prepare something that's actually really simple, but you can't know that, and it isn't simple for you, and you do that for a while, and then you kind of go, oh, that was simple, I'm all over that now. It takes me 10 minutes to prep, and you're fine there, but probably only for a few months, and then they go, oh, you can do that, so now you need to step up to this level of work, and you go through that same in sort of jumps for a while of kind of new work, and then feeling confident about it. And I also think over time, your working practices just change very much, you know, as to what your family life is and where you are and where you're working. Sometimes you need to sort of come home, have time off and work again. Some people work better in the mornings. And I think that's just that's a really personal thing about how you manage your life with the preparation and the court work and any other commitments that you have.
Okay. Jane, are there any other relevant questions that we should deal with at this point?
Yeah, we've had a couple of questions in relation to self-employed practice at the criminal bar. So I think it'd be great if John or Karma could explain how you're able to work for both the prosecution and the defence when you're working as a self-employed barrister.
I don't think John does, looking at the chat. Do you? Do you not prosecute?
I do a little bit, Karma, for my sin.
Okay.
Yeah. Sometimes I'm on the bad side.
No, you see, I've gone the other way. So, and I think that's as crime develops as well. So, like probably most of us, you know, I came into sort of only wanting to do publicly funding from a sort of left-wingish perspective. And, you know, I'd been involved in lots of sort of young offenders, volunteer groups and things like that. So my natural home was just to defend. But as time progressed, they become the crimes that you're dealing with. They're no longer sort of a poor lad who's made a bad mistake and you really want to help him. You know, they're like really evil child abusers. And actually you get a lot more job satisfaction out of prosecuting them. So, I mean, that's just a personal thing about why it changes sometimes over time, the work that you do. But fundamentally, it's, you know, it's just all goes back to our sort of code of conduct and our professionalism, doesn't it? That we are there to be the advocate for that side that's paid us, as long as we're operating within our code of conduct, you know, either presenting the case fairly if you're for the Crown, fighting fearlessly if you're for the defence. And it's the whole of that is the criminal justice system. You know, you want every crime, we all want to be prosecuted by a fair prosecutor, you know, and every crime we want to be defended by a robust and fair but not sharp defence advocate. You know, if we want a working and operational criminal justice system, we want the best in both of those sides. So there's absolutely no disconnect whatsoever for me for working on both sides, crime, defence and prosecution. And I think you probably, you almost need to have a word with yourself. Do you know what I mean? If you've really got strong views about never, ever touching the other side, I mean, what are you saying? You want to work in a system where nobody's defended or nobody prosecutes? I mean, having said that, the skills are very different. So prosecution, it's your show. You know, it's, you make all the decisions and you lead a team eventually of police and you can make things happen. So there's a whole different skill set. It's all about being prepared early and thinking through the issues. And the defence is, you know, it's far more about being robust and thinking about ways to be able to say no to legal applications.
They are very. It was always described to me by one of my senior members of Chambers as, you either enjoy building the sandcastle or kicking it down. There are two types of people in the world. And I think it's probably not a bad analogy, but I think I agree with you. They inform each other, and because of the work I do prosecuting, sometimes I feel it gives me a better understanding when I'm defending of where I can push buttons to advance my client's case, either in a disclosure sense or in another sense, and I can engage. Of course, Jo's here, who only defends, so we'll hear from her.
Well, you need to have a word with yourself, Joe. I told you.
But I'm one of those lefty liberals, Karma. No, but in seriousness, certainly Garden Court, and there are a couple of other chambers that are like Garden Court, were obviously built and came into being at a time when things were very different, actually, culturally. And in it was very difficult for defendants to potentially get a fair trial. It's as simple as that. And there were lots of injustices. Things have changed quite dramatically since then. And I only defend, and that still comes through from that long tradition, actually, of being at Garden Court. But ultimately, very, very firm believer in our system whereby the vast majority of the criminal bar both prosecutes and defends, because ultimately otherwise you end up with what they have in the US. And I practiced there, I worked there for 5 years. It's a very polarized system where you have your prosecutors and you have your defense lawyers, and you see it a little bit actually in some of the other areas of law within the UK where you have that polarization of applicant or claimant defendant lawyers. And I think there's a real benefit, there's a real strength to our system, which is that every individual that prosecutes or defends is independent. And from my experience, some of the very, very, very best prosecutors are those that also defend, and vice versa, actually. Because unless you have that objective eye on the evidence and that objectivity to say, well, actually, if I'm prosecuting, these are my weak points in this case, and this is what these are the high points. And if you're defending to do the converse, which are, you know, these are the weak points in the prosecution case, but actually I've got some really weak points here too, and this is where the prosecution is going to hone in quite sharply. I need to deal with those, and unless you can identify those, if you solely defend, I think you become quite siloed in your approach to cases, and then you may open your case at a very high level that actually the evidence never comes up to if you're prosecuting. And if you're defending, you never deal with those obstacles. So I'm very much a firm believer, ironically, in the concept that certainly the majority of the bar should prosecute and defend. I think it would be a real loss, actually, if we all ended up either just doing one or the other. If that helps.
Yeah, I feel that really
myself.
I feel that really strongly. I particularly feel that when you get into the field of sex cases. I really do, because I think then you actually can come across some really unfortunate attitudes, actually, on behalf of the defence bar, because they haven't done the other side and they haven't dealt with the complainant. So, yeah, I think, yeah, it's funny. I mean, I won't go into this too much, but I think the lefty liberal side that often brings us to defend, and then my feminism in wanting to prosecute the rapist one out. So, you know, I think that's just what it was.
I've always been told that I would make a pretty, what's the word? Vicious prosecutor in those types of cases.
One day I had a moment, you know, I had a moment when the sort of nonsense went off laughing, and that was it for me. But no, I think the message is I think it's eggs in baskets as well. I think it's all very well us talking about the luxury, to a degree, the luxury of what we choose and have made choices over the years as what best suits us. But actually, you know, in your early days, you're just really happy to have briefs in your name, aren't you? And for work to come through the door, in all honesty. And what I would say, just from a really economic or financial point of view, is the CPS hold 50% of all briefs that exist at the criminal bar. And I know that's stating the obvious, but someone said it to me when I was fairly junior, and I kind of realised I hadn't thought about it before. So you might make a link with a good firm of solicitors and they start briefing you. That one individual could leave or move on at any time, and that seam of work has dried up. But actually, just in terms of thinking about as a provider of work, and it's the same with family to an extent with the local authority, you know, the working practices might not always be as good. Sometimes the money isn't as good. Sometimes it is actually better. But there is so much work there that I think if you're in a mixed set, it would be sensible to try and have work from as many different streams as possible.
I would again caution students against pigeonholing themselves into one side of the profession at the criminal bar or the other until you've tried both. You know, it's one of those things where you don't close off doors on some sort of ideological basis. Wait until you try it, see if you like it. If you don't, you don't. If you do, well, there you go. You opened yourself up to a whole new revenue stream. Worthwhile.
Just to draw Paul into this conversation for a moment, I think it's equally fair to say that the vast majority of family practitioners act both for families, individuals, private individuals, but also for local authorities or indeed instructed in terms of the children's guardian in proceedings. Is that fair, Paul?
Absolutely. There's very few, certainly at the bar that I can think of, that only do one or the other, whether, as it were, on the prosecution side for the local authority or defence from the perspective of the parents, if I can simplify it that way. And I agree entirely with what John says, and indeed Karma, in terms of the balance that gives you, the ability to see your case from another perspective, and to understand and think, actually, if I was for the local authority in this case, what would I be doing? And as Karma says, the local authority holds a substantial amount of work in every single case. There is always a local authority barrister present in every single set of care proceedings that I work in. Well, there's not always a local authority barrister, and that's part of the problem as well, because a lot of local authorities have started taking work in-house, much as the CPS have done for many years. And that does, in some respect, cut off some of the work at the junior end. So it's important to take those opportunities when they arise. So that may be at 4 o'clock on a Friday afternoon, the local authority nearest your chambers phones up in a desperate panic and says, we need someone to cover this. And you might think after 5 days in court, I don't want to do that. I really, really am fed up. But by doing so, I have opened doors in terms of my work and getting that balance either side, getting regularly instructed. And because at the junior end, you tend to be a bit cheaper, at the local authorities certainly will, I've often found, give you work which you may not necessarily get if you were working at it from another perspective, because you are slightly cheaper. So you get to build your experience and cut your teeth on better quality work from a very early stage. So don't limit yourself, I think is the message that all panelists have given us.
Yeah, despite the good fight, whichever side you're on, in short, I think is the answer.
Basically, yeah.
It's never black and white. It's never black and white in my experience anyway. So. Okay. Moving perhaps on, just on to then perhaps dealing with pupillage, because I know that a number of the students on today's sessions will be interested, obviously, in applying potentially for pupillage in the future. What advice would you give to pupils, and what does your set really look for?
I'm happy to go. Is probably I think I'm probably the most recent out of pupillage. It's closest to me in my mind. my advice for pupillage is the first 6 months is just to soak it up. That's what I got told by my supervisor on the first day. Just listen, look, observe everything, see how your supervisor goes about things, and ask questions at the appropriate time. And that's at the end of the day on the train back, when the dust is settled, your supervisor is not stressed, not dealing with the client, not dealing with court staff and everything else. Second 6 is just about working and enjoying it, and it will go so fast. It'll be over in a flash, and you'll look back and think, God, that was a brilliant time in my life. But in terms of pupillage and what people are looking for, that's obviously a highly subjective question and likely to vary from chambers to chambers. At my chambers, I don't deal with the pupillage side. I deal with mini pupillages, but having spoken to the people on the panel, I know what we try and look for is obviously solid academics and everything else that goes along with that, but some kind of personality, a spark, because ultimately you're joining a set of people, you're going to work with them. We want to be able to go down and have a drink with you at the pub on a Friday when the pubs reopen. And it's just, having an interest or being interesting outside of being just a solid lawyer is something that's important to us. So that probably is what I would say. And just in your interviews, just try and relax. Don't worry about it too much. Just be yourself. Don't try and speak like a barrister. Don't worry about looking like a barrister. Turn up in a appropriate smart dress, but don't get bowled over with some weird TV image or what a barrister should look or sound like. In reality, that's not how we operate, especially at the criminal and family bar, I would say. Yeah,
and perhaps if I turn now to Karma. I'm just very aware we've only got about 3 minutes left, and I think that the sessions actually automatically end. So go, Karma. Oh, you're muted, I think.
All these questions about juggling different areas of family and crime and so forth together, but I mean, last words are just I still absolutely love my job. I'm 23 years in, and after a period of time of quarantine, lockdown, I thought I wouldn't. I've come back and I'm really enjoying it, and I've done nothing really but publicly funded work, so don't let that put you off.
And Paul?
Exactly the same. I'm somewhat less cool than Karma, but I think the thing which all of us have in common who do this sort of work is that passion. It's that passion for working with individuals, because each one of our cases has an identity, whether that's a defendant, a complainant, a child, or a parent. And from my perspective, I try never to lose sight of that, because the people we work with at the publicly funded bar tend to be those who wouldn't have a voice if we weren't there.
Okay, so perhaps just drawing all of those threads together, I think we all appreciate that there are challenges facing the publicly funded bar at the moment. I hope that we've answered most of your questions. I appreciate there's certainly specific ones in relation to juggling family commitments and practice areas, and perhaps we can have a little chat about that shortly. I just know that we've only got a minute left. It can be done, though. I think that's probably the message that needs to go out there. It can be done. I think chambers are becoming far more supportive now, and are stepping up actually in relation to supporting individuals with either family or caring commitments and responsibilities. And the courts are having to take that on board in a very different way for the first time. Both practice areas are developing protocols and things like that in relation to well-being and case management. It's perhaps come all the more to the fore actually, and it's accelerated it, I hope, owing to COVID, because obviously COVID has presented its own unique challenges, and so we hope that we can certainly learn lessons from that. So don't let that put you off. Karma's doing it as a mother. Her children are fairly advanced now compared to mine. I'm doing it with a baby. It can be done. You might see the baby in a moment. You might pop back in, but it can be done. And I think that we're all, the support is out there. So I think we'd all just encourage you to, consider a career at the publicly funded bar, because it genuinely is, I think, for what it's worth, having practiced across different practice areas, the most rewarding areas to practice in, because you're dealing with real people, you're dealing with real lives, and the impact and the consequences and ramifications of the decisions that you are making and the courts are making obviously reverberate not only in their lives but through generations. So certainly I encourage you all it's really not all doom and gloom. And thank you very much. And obviously feel free to pop into the networking area. Networking does allocate individuals randomly, so you won't be able to ask for John or Karma or Paul, I'm afraid, as much as you'd like to. That's certainly my understanding, Jane, of how it operates.
That's right. But as I said, all the ICCA staff are practitioners, so they'll be able to answer any questions that you might have.
So thank you all very much, and I hope you enjoy the rest of the day. And thank you very much to all of our panelists who've taken up and given up their time this morning on what certainly for me is a wet, rainy, windy morning back in Gloucestershire. So take care.
Thanks.
Thank you, Jo.
Thank you.